Assalamu alaikum everyone. This is another short video regarding the types of contract under the Contract Act. So we have already learned about the promise and contract agreement. And in this video, now we will learn about how many types of contract are there under the Contract Act. As we know that the contract is an agreement which is enforceable by law. So when it would be enforceable by law, then how many classifications we have under the Contract Act? So let's begin. So first is the classification of contracts, uh, uh, and this classification is under the formation criteria. So, in how many types of contract can be formed? The first one is a bilateral contract, yeah, promise for a promise. Like it is a simple, like if someone offers, for example, Mr. A offers Mr. B to deliver 1,000 goods at his warehouse, and Mr. B accepts the offer and promise to pay rupees 5 lakh against the delivery. So this is the bilateral contract. Here two parties exist, and each party promise the other party regarding certain consideration. So this contract can be called as a bilateral contract. Now the second one is unilateral contract, a promise for an act. Unilateral contract is something different. Under the unilateral contract, there is only more than one party, but there's a one party who actually going to perform, who actually going to give his or her performance, but not on the other side. So this is a unilateral contract. What type of contract is this? Uh, there are some exceptions. In our next videos, we will learn about the unilateral contract deeply, but here are very precise example. Under the Contract Act, we knew it in our earlier video that there should be a consideration from the both sides. But there are some exceptions. Let's suppose if there is a love and affection, okay? Under the love and affection, if someone promise the other person that he will pay rupees 30,000 per month, and he sign a contract with other person to whom or with whom they have a relationship with love and affection, and in some day or in future, if he will not pay that sum of money which he promised, then the other person can sue him. Okay, so this is a unilateral contract. Here, only one party is actually bound to perform his performance, not the other party. The third one is the express contract, a contract expressed in oral or written words. So, simple as a definition, if two parties have a contract and there are two ways. The first one is there may be a written agreement. Okay, this is also express contract. And the second one is a oral contract. Yes, orally they they promise each other, in order to perform their performances. But I think there not I think according to the law there should be some witnesses, because in future if anyone um, breach the contract or does not perform his contract, then how you will sue him. So there should be a proper witnesses of when you promise someone orally. Fourth one is the implied in effect contract, and we can also call it as a simple implied contract. Implied contract is something different. Like Mr. A offers Mr. B. First of it, the definition of implied contract is a contract inferred from the conduct of the parties. Okay, if the conduct of the parties induces that that party agree to participate in this contract, then it will be called as an implied contract. How? Mr. A called Mr. B and said, I want 5,000 bale of cottons tomorrow before 9 a.m. If you will deliver before 9 a.m., I will give you that sum of money into your account. I will deposit that money into your account. So at 8 a.m. tomorrow, Mr. B deliver his required quantity of bale of cottons to his warehouse. Now, because of this conduct, because of this act, we can say that Mr. B and Mr. A are now in a contract, and that is implied contract because the conduct of Mr. B by delivering goods to Mr. A before the prescribed time, which he intimated to the other person, to Mr. B. Now they are bound in a contract. Now Mr. A is liable to pay that certain sum of money against the delivery. So this type of contract is called implied contract. So there are the first four examples. The first one is the bilateral contract, second one is the unilateral contract, third is the express contract, and the fourth is the implied contract. Now here, fifth one is a quasi contract. A contract implied by law to prevent unjust enrichment. Okay. Quasi contract is like Mr. A issue loan of 1 million rupees to Mr. B, and Mr. B promises Mr. A that he will pay the lump sum amount after 6 months. After 6 months, Mr. B is not in a position to pay the lump sum amount to Mr. A, and Mr. C is a friend of Mr. B, and he knows each and everything about Mr. B, his financial status, and his financial credibility, or you can say he knows it that he is unable to pay, and in case if he will be default, then maybe he have to sell out his sort out his assets. Now Mr. C, not gratuitously, Mr. B, sorry, Mr. C asked Mr. B that he will pay that sum of money, that loan to Mr. A on behalf of Mr. B. When Mr. C will pay the loan on behalf of Mr. B to Mr. A, now Mr. B and Mr. C are bound in a quasi contract. Now Mr. B is liable to compensate Mr. C in future uh, according to the sum of money which Mr. C has paid to Mr. A. The characteristics of a quasi contract is it is act by the third party, and it is not bona fide act, because if it is bona fide act, then it is not a contract. It should not be a bona fide act. Bona fide act, like Mr. C is not paying on behalf of Mr. B upon the intention that he will not get back that money from the Mr. B. He The intention is he will get back that money from Mr. B in future. Right now, he is helping him and he is paying some of money on behalf of him. So this is a quasi contract. Now, the sixth one is a formal contract, a contract that requires a special form or method of creation. Formal contract, if two parties are going to promise each other, and eventually if it is enforceable by law, it will be converted into contract. But if that contract has some type of special form before creation, like they have to submit some sort of papers to some association or to any NGO or to any legal body, then it will be called as a formal contract. Now, the opposite is the informal contract, that is a number seven, a required that requires no special form or mode of creation. So it is actually individual contracts that does not require any sort of special or prescribed form. So this is called as an informal contract. So according to the classification of contract, under the criteria of formation, there are these seven types of contract. The first one is a bilateral contract, second one is a unilateral contract, third one is express contract, fourth is implied contract, fifth is quasi contract, sixth is formal contract, and seven is informal contract. So if we move forward, now the classification of contract according to the criteria of enforceability. So first one is a valid contract. Now, what is valid contract? I require a contract that meets all of the essential elements to establish a contract. And what are the essential elements of any valid contract? We have already discussed in our video number 2, essentials of a contract. If all those essentials are available, exist in that contract, then we can call it as a valid contract. The all two parties are major, not minor. They should be a rational person, a sound mind person, and the consideration should be legal, the act should be legal. So each and everything constitutes essentials of elements, and if any of the element is not available in that contract, then it is not a valid contract. The second one is a void contract. No contract exists. Void contract are those contracts which does not possess all essential elements of a valid contract. So these contracts are a void agreement. Like Mr. A deliver a certain amount of drugs to Mr. B, and Mr. B paid um, certain sum of money upon the delivery. So this is a void contract because the consideration is unlawful, and if consideration is unlawful, then that essentially is not available in a contract. So that's why we can call it as a void contract. The third one is a voidable contract. A party has the option of voiding or enforcing the contract. Okay, Mr. A has two type of goods of quality A and quality B. Okay, now Mr. B call him and ask him to deliver 5,000 goods of quality A. Unintentionally, by mistake, Mr. A delivered goods of quality B to his warehouse. Now, Mr. A, after the delivery of these goods, has an option whether to accept either to accept these goods or reject. If we accept these goods, then the contract will be enforceable. If we reject the delivery because the goods are not that quality of that prescribed quality, because it's a quality B and he was looking for a quality A, then the contract will be void. So if in any contract, if this option is available for the innocent party, that either to accept or reject, then these type of contract are called as a voidable contract. Fourth one is unenforceable contract, a contract that cannot be enforced because of a legal defense. This is something like void contract, or it cannot be enforced because of a legal defense, because it may there may be a consideration is unlawful, or any act which is immoral or opposed to the public policy. So these contracts are not enforceable by a law, so we can call it as an unenforceable contract. So these are the four types of contract under the criteria of enforceability. Now, the classification of contract according to the criteria of performance. There are two types. First one is executed contract, and second one is executory contract. So, in executed contract, a contract that is fully performed on both sides. Mr. A has delivered the goods, and Mr. B has paid that sum of money to Mr. A. Now, nothing left. So, this contract can be called as an executed contract. We can call it as a past contract because the performance has already been done. The second one is an executory contract, a contract that is not fully performed by one or both parties. Here, like Mr. A and Mr. B has promised, like Mr. A promised to pay to deliver goods to Mr. B, and Mr. B promised to pay some of money to Mr. A. Okay, now nothing has been happened. It will happen tomorrow. So this is executory contract. Now tomorrow, Mr. A delivered the goods to Mr. B, but Mr. B has not paid yet the asking amount. So it's still the executory contract because the performance of one of the party is still not fully performed. So this is the executory contract. So these are the type of contract according to the classification of performance. And earlier, we have learned about the classification of performance, classification of contract according to the enforceability and formation. So thank you so much.